it is time for us to get back to Massachusetts. Things have been speeding along in the multitude of Karen Read cases. So what we're going to do today is we're going to fly to Massachusetts. Then I think we look at the Proctor phone discovery first, because that is taking place like a case within a case within the pending criminal cases of Miles King and like 5 other defendants. So I think we take care of the Proctor phone stuff first, which gives us a little bit of background before we jump into recent filings as recent as yesterday in the Karen Read federal civil case. But it also gives us a heads up where the Karen Read team is looking at going. And then it sets the stage, I think, for what we're going to be talking about tomorrow, which are more discovery issues in the civil wrongful death case. Buckle up, everybody. It's going to be busy. We saw the Proctor texts in the Karen Read criminal trial. And it seemed that Proctor was not worried at all about all the shit that he was texting to his supervisors and whatever. There was an entire like half day of testimony of Buchanan being like, no, I thumbs up it on my Apple Watch. I didn't really read it. I gave it a thumbs up on my watch. It was on my watch that I thumbs. Right. So after that, in the ongoing criminal cases that Proctor was continuing to deal with, other defense attorneys, because of course they did, were like, yo, what else is on Proctor's phone? And whatever triggered them getting into Proctor's personal phone, the discussion around the personal phone from Proctor's attorney before Proctor withdrew from the civil service hearings. So this was all ramping up to Proctor fighting his termination. And then they had done a phone dump of Proctor's personal phone. Apparently, Proctor's iCloud was connected to the phone, and they got a phone dump of 13 years plus of information from Proctor's iCloud. Proctor withdrew his appeal at civil service and was like, fine, I'm fired. And then his attorney was like, and we're out. We were the civil service attorneys. We represented him in civil service. He's out of civil service. We're out. All happened like the next day. And then the fight began in court over what was going to get turned over to the defense attorneys in the 5 ongoing criminal cases where Proctor was like the lead investigator, not the lead investigator, case agent, whatever, because they can go to bias. If he's talking about Karen Read the way he's talking about Karen Read, do you think he's not talking about other defendants similarly? I don't. So in the Miles King and other cases, the fight over Proctor's phone was allowing information to be turned over to the defense attorneys in those 5 criminal cases. And then Karen Read's attorneys were like, hey, can I get that discovery? See, we've got this other case in the wrongful death case, and part of Karen Read's defense in the wrongful death case is a conspiracy, a failure to investigate, a cover-up, and a setup. So the shit on Proctor's phone, you can see how it would be relevant to her defense in the civil case. But then Karen Read's attorneys went back into court and were like, hey, so about that, you've allowed us to use Proctor's phone in the wrongful death case. But we also have this other civil case where we're suing Proctor and like everybody else. So what we need is to be able to use what you've given us in the wrongful death case. We need to be able to use that in the federal Karen Read sues everybody case. So could we modify the protective order to allow it to be used in the state case and in the federal case? Okay, thanks. And that's where we're picking up in the middle of phone fight part 2 over Proctor's phone. The Commonwealth has objected. Proctor has objected. Karen Read has responded. From what I can see on the docket, the court has not ruled on this yet. It seems to me to be a reasonable request. I imagine, since the court has already granted it in the wrongful death case, the court will expand the protective order to also include the civil case where Proctor is getting sued. Tully is retiring. Let's take a look. This is coming from NBC 10 Boston. Former head of Massachusetts State Police unit that investigated Karen Read retires. Massachusetts State Police Lieutenant Brian Tully, who oversaw the investigation into John O'Keefe's death and testified at Karen Read's trial, has retired. State Police confirmed his retirement was effective at the end of the day, Wednesday. This article is from April 11th, so last week. State Police confirmed his retirement was effective at the end of the day, Wednesday. Tully's most recent post was part of the Field Services Division. An MSP spokesperson told the Boston Herald that that's where he had been reassigned to. I don't know what Field Services does. Feels like a desk. He formerly led the detective unit for the Norfolk County District Attorney's Office. Weeks after Read's first murder trial ended, state police announced in July 2024 that they were investigating 2 troopers, including Tully, who testified at Read's trial. Tully was transferred out in October 2024 after a new leader took over the entire agency. He was found to have violated department rules and regulations. Oh, you don't say. So he's retired. He will still come in and testify on cases that he needs to. We'll be hearing more about Tully as we cover other cases, but yeah, we did Karen Read Sues Everybody a number of months ago. The original filing that we talked about this in context was a court hearing plus where Karen Read, well, I think it was Alan Jackson, was talking in court about how in the wrongful death case, he was bringing in or wanted the court to bring in a whole bunch of cross defendants. So the O'Keefes sue Karen Read, and then in the same case, Karen Read sues everybody else. And then they have cross defendants in the same case. They were going to sue in state court, and I think they filed the original one, and then they were going to litigate whether it would be allowed, and then it got removed to federal court. In getting removed to federal court, there was an amended complaint that was filed by Karen Read at the end of middle of last month, on March 13th. We are not going to go through all of the amended complaint. If at some point we need to, we will circle back to it. I am going to go through who the parties are and what the causes of action are, but we know what these allegations are essentially. This is the amended complaint. Karen Read versus Michael Proctor, Yuri Buchanek, Brian Tully, Canton, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins. Karen Read sues everybody. For 3.5 years, plaintiff Karen Read was wrongly accused of homicide and subject to suspicion, arrest, 2 prosecutions, public condemnation, all resulting from the gross misconduct of MSP and those working in tandem with MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Read brings this action to recover for and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who abjectly failed to ensure that justice was sought and served in the aftermath of January 29th, 2022. Count 1, 42 USC 1983. Right. Civil rights violations. This civil rights violations, even though they're against Proctor, Buchanek, and Tully, the other defendants moved to remove this to federal court because there is a federal subject matter. You are allowed to move it to federal court. Proctor, Buchanek, and Tully violated Ms. Read's Fourth Amendment rights by engaging in a malicious prosecution of Ms. Read by causing her to be seized pursuant to legal process unsupported by probable cause. This is your malicious prosecution section. There will be more. These are the federal claims that tie this into federal court. Count 2, supervisor liability under 42 USC 1983. They go on to say a supervisor is liable under 42 USC 1983, where the supervisor supervises, trains, or hires a subordinate with deliberate indifference towards the possibility that the subordinate's deficient performance will result in a deprivation of an individual's constitutional rights. It goes on to say that Buchanan and Tully knew or should have known that there was a grave risk that Proctor would fail to investigate the Alberts with whom he had a close personal relationship, which he had disclosed. And do we see why the phone becomes such a big deal? They also knew or should have known that there was a grave risk, not grave concerns, grave risk Proctor would wrongly seek to have Miss Reed charged given the manifest bias evidenced in his text messages, which were sent to Buchanan, among others. Count 3, conspiracy to deprive Reed of her Fourth Amendment rights against all of the defendants, Proctor, Buchanan, Tully, Alberts, McCabe's, Higgins, that they were all involved together in not coming forward. That's what this allegation is broadly. Count 4, Massachusetts Civil Rights Act against Proctor, Buchanan, Tully, the Alberts, McCabe's, and Higgins. That those defendants interfered or attempted to interfere with Miss Reed's exercise or enjoyment of her rights under federal and Commonwealth constitutional law through threats, intimidation, or coercion. Count 5, common law malicious prosecution. There are 2 causes of action here. One for malicious prosecution under the federal law and one for malicious prosecution under state law. That includes the Alberts, McCabe's, and Higgins. Notice under the federal malicious prosecution, they did not bring in the non-law enforcement individuals. Here, they brought in the non-law enforcement individuals under the state law. And it might be that they choose to go forward with the common law malicious prosecution because it seems that they can bring in the Alberts, McCabe's, or Higgins. Maybe they can't. Maybe it will get yeeted down the road, but maybe Massachusetts allows for the individuals that cooperated with police to also be sued for malicious prosecution, which would actually be an interesting difference between Massachusetts law and federal law. Count 6, intentional infliction of emotional distress against all the defendants. Is there a question, now whether it was intentional or not will be a question, but is there any question that this caused a significant amount of emotional distress? I think that that's true. Count 7, civil conspiracy. Y'all agreed. A civil conspiracy is an agreement to do a thing. Y'all agreed. Jury demand, yes, a jury trial. Of course, yes, a jury trial. And then their prayer for relief, judgment in Karen Reed's favor against all defendants, award of damages calculated at trial along with pre and post judgment interest, costs, and expenses, reasonable attorney's fees, other such relief. That's your basic damages. We see that we've got both law firms on this, Alan Jackson's firm, and then Damon Seligson is the other attorney representing Karen Reed that we've seen at some of those hearings. In this case, we have the beginnings of people answering complaints, initial motions to dismiss, discovery is going to be beginning. And in that context, there is a very interesting motion from Trooper Proctor. Leonard, have you seen this story coming out about the FBI being hacked? I know.
The FBI!
Right. Early reports at the beginning of April indicate that foreign actors were able to hack into the FBI and get into the systems that they use for wiretapping. The FBI can't keep their systems secure. What hope is there for the rest of us? Well, that's why I have Incogni. Incogni goes out to all those data brokers and gets your information taken down. But it's not just that Incogni does this once. You sign up once and then their system is fully automated and it keeps scouring more data brokers. And Incogni is one of the only places that I've seen offer a custom removal feature where you can work directly with Incogni privacy experts to handle specific and customized takedowns of information online. Plus, you can see where your data is getting removed from, which helps you take back control of your personal data. And you're not constantly scouring the internet trying to see if one of these leaks impacts you, because it's just handled. Incogni knows you're going to love it. And just in case you don't, they offer a 30-day money-back guarantee, so you can cancel anytime. Leonard, I know you're ready to check it out and take back control of your personal data with Incogni. Just go to incogni.com/Emily and use code Emily to get 60% off annual plans. And Leonard, I know you will rely on Incogni as much as I do. Now let's get back to today's case brief. Docket 67. Defendant Michael Proctor's memorandum of law in support of his motion to conduct limited discovery to third parties prior to the court's establishment of a Rule 16.1 and Rule 26F conferences. Proctor seeks leave of the court to serve the attached two keepers of the records subpoenas on the Norfolk County District Attorney's Office and Canton Police. Proctor wants discovery from the Norfolk District Attorney's Office and Canton Police Department. As grounds, Proctor states that good cause exists to allow this motion as he is scheduled to be deposed as a witness on June 8th in a parallel case pending in the Plymouth Superior Court. Wasn't Proctor just in court objecting to discovery, being like, oh, they don't even go here? Why aren't you filing this in the civil wrongful death case? Oh, because you're not a party in the civil wrongful death case. So you want to come up in this federal court and be like, hey, Your Honor, can I go ahead and use the subpoena power of the federal court to get documents to prep for a deposition in a not this case? You want to prep for your deposition in not this case? Go ask that judge. Why are you asking this judge? You want to go complain in the Miles King case that she doesn't even go here. And why is Karen Reed coming up in here asking for the phone discovery that's governed by that court? And you're asking this court that does not govern the processes in that court, asking for discovery to prep for your deposition. Does the deposition cover both cases? Maybe I crashed out preemptively. But that's not what you said. You said scheduled to be deposed in the wrongful death case. And plaintiff's counsel, who represents Miss Reed in the state court case, has refused to provide Proctor with sufficient material with which to prepare for that deposition. They are in fact asking for the subpoenas because Karen Reed's lawyers didn't give it to them. They're saying now there's good cause for us to go get it, but you're still in the wrong court. But he's saying, look, we're going to have to get this discovery from the federal court at some point because we're the defendant here. So can we expedite discovery on Norfolk DA's office and Canton PD? Okay, fair. Proctor is scheduled to be deposed by Miss Reed's attorneys in the state court case on June 8th. Whereas Mr. Proctor is no longer employed by the Massachusetts State Police. He lacks access to all the documents and evidence arising out of the two criminal prosecutions of Miss Reed. Oh no! Go subpoena them! Oh! Moreover, Proctor's counsel has requested that Miss Reed's attorneys provide Mr. Proctor documents sufficient to refresh his memory in advance of the deposition. But Miss Reed's attorneys have refused to do so and stated they have no obligation by rule or other law. Yeah, they said fuck off, but like nicely. The argument to the federal court is, but Your Honor, Miss Reed won't give it to us, so you need to let us expedite discovery on the Canton PD and the Norfolk DA's office. So you need to let us have a subpoena early because this is going to come up in this case. So just let us have a subpoena early. That's a fair argument. The asking Karen Reed's attorneys for it is bold, but they're coming in there saying, look, we tried to go a different way and we can't. And the good cause they are saying is that Proctor is scheduled to be deposed. I don't know if the court's going to find that good cause to accelerate discovery in this case, though. What Proctor's attorneys are asking for in sum is to allow or to have the federal court expedite discovery and allow Proctor to use the federal subpoena in the federal case where he's a defendant to go get the case files from the district attorney's office and from Canton PD early before discovery is set in the federal case so that he can have access to it to prepare for his deposition in June. Now, Karen Reed's civil wrongful death case is where this discovery has been propounded. They are not asking for this in the civil wrongful death case as an intervener. So Proctor didn't go to the case where that's happening and say, hey, I need the discovery to prep for my deposition. Can I have a subpoena to go get it? They went instead to the federal court to ask. And the fact that they thought that Karen Reed's attorneys would be like, oh yes, let us piece through all of our discovery and make sure that you have it. No, they're not obligated to. So could the federal court allow them to subpoena the DA's office and subpoena Canton PD? Maybe, but it would be expediting the discovery. But Karen Reed's attorneys responded yesterday. Let's see what their objection is. Shall we? Other than, like, seriously, bro, what? Opposition to defendant Michael Proctor's motion to conduct limited discovery. The court should deny former Trooper Michael Proctor's request to take early discovery in this case for the sole purpose of using it in a separate ongoing proceeding in another case in Massachusetts State Court. Your Honor, they're trying to skip the line. I agree with the next part. Proctor does not point to any case, statute, rule, or other authority supporting his request because there is none. If Proctor truly believed he had any right as a non-party deponent in a civil case in state superior court to discovery of or access to any of those documents, he would have sought them in such court. Oh, good. I'm not crazy. Good. Okay, good. Apparently, they say, recognizing he does not, he instead asks this court to assist him in circumventing the state court rules. The court should not do so and should deny Proctor's motion. Karen Reed's attorneys were actually asked by former Trooper Michael Proctor's attorneys to turn over all of their discovery to Trooper Proctor to refresh his recollection prior to his deposition. Here's the quirk on that. He's asking in the federal lawsuit where he's being sued, not the state lawsuit where his deposition is pending. And he is saying to the court that, Your Honor, them not giving it to me is good cause for me to get a federal subpoena to go to the district attorney's office in Norfolk and Canton PD and get their case files. So could you let us just accelerate the discovery so that he can refresh his recollection prior to his deposition in the wrongful death case? And Karen Reed's attorneys responded on April 13th and said, so, there's not like a mechanism under the law for this to happen. And you should go ask in the state court, which he has not done yet. He has not sought to intervene in the state court asking for the file to prepare for his deposition. If this is going to be sought in discovery in the federal case, and it's discovery that Karen Reed already has, and the co-defendants don't oppose it, the federal court might say, yeah, we can issue the two subpoenas, go subpoena them. But the federal court might also say, I'm not ready to be the referee on you fighting to get discovery from Norfolk DAs and from Canton PD. I don't want to referee that discovery fight that's related to another case, because that's not related to our case. And this isn't a discovery fight I want to have to referee yet. So you're not putting this work on my court. We got other shit to do. Go ask the court you're getting deposed in. And the federal court can do that too. They can say, this is not our problem. And we're not going to create a problem that doesn't otherwise exist. So you can go get it elsewhere for now, or you can wait until after our hearings. But there are motions to dismiss pending, and the court's got plenty of work that they need to do on the pending motions. So the federal court could do either, or you know what federal courts are really good at? Federal courts are brilliant at, well, we don't need to expedite an order on this, and maybe we need to have a hearing on it. So why don't we schedule a hearing? And then by the time the issue's resolved, it's past the time that it's needed. And then the federal court is like, oh, I didn't need to rule. I guess it's moot now because, well, we're past the date for that deposition. So we'll get to it. It's not that federal courts are particularly speedy in their rulings when they don't need to be. And Karen Reed's attorneys, to their credit, responded incredibly quickly to this. I'm not sure what the federal court's going to do here, but it's very likely the federal court could let the clock run on this because it's a pretty tight clock between now and Proctor's deposition, which is probably what has Proctor pretty stressed. So what's going to happen with the discovery that Proctor is trying to get from Norfolk DA's office and Canton PD? I guess we'll have to wait and see which court allows him to subpoena the keepers of the records. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.